So at the end of the day, it is totally adjudication, and at the end of the day, on arbitration, the arbitral award is the end. Madhavendra Singh sir was also justified that how the amiable compositor term is unknown for India. However, it's adopted from ancestral law. Significantly, we know that countries which follow model laws are model law countries, and in such moment, such countries has been given arbitration that kind of legibility too. I am sure we understand that the basic terms like place, venue, and seat, these terms and its importance were much discussed topics on our previous session, not only on the previous session, but on the every session. Still, Madhavendra Singh sir quoted and highlighted those parts too. He enlightened the amendment part took place on our Arbitration and Conciliation Act 1996, basically the 2015 and 2019 amendments, which introduced large-scale radical changes to the Arbitration and Conciliation Act. Some of the notable changes were aimed at reducing delay during arbitration proceedings and where the enforcement of arbitral award, so and so. Before commencement of Arbitration and Conciliation Act, I mean the Amendment Act 2015, Section 36 of Arbitration and Conciliation Act 1996 provided. So in total, we can say that uh, so in total, we can say that rights of a bona fide award holder, those who preventing him from reaping the fruits of the same award, automatically stays. Significantly, sir easily mentioned that existing section 36 provided with the remedy of under section 34. Then he commented on the cutoff date in the sense of time where Arbitration and Conciliation Act amendment commenced on or after the date of 2015 October 23. Then he falls into the 2019 amendment, which completely altered the arbitration regime of India. Major amendment was introduced was section 87. Yeah, by the way, section 15 of 2019 also omitted section 16 of the 2015 Act. Now moving on to the sections that Madhavendra Singh sir was mentioned, and to sections which basically falls under scope of interventions of courts. He started with the basic by defining section 2 clause 1 clause E, which defines the courts. The competent court can decide over subject matter of arbitration, but we must be aware that it doesn't include any civil court of grade. Section 5, next section 5 says on the extent of judicial intervention. It provides for extent of judicial intervention in arbitration, and therefore no judicial authority shall intervene. Section 8 is a peremptory in nature. It refers that the parties to arbitration. He also said that the arbitral agreement is the basic where judicial authority directs parties to go for arbitration. Section 9 says interim measures of court, and Section 17 says interim measures by arbitrator. Both aspects were much discussed in the previous sessions. After 2015 amendment on Arbitration and Conciliation Act 1996, arbitral tribunal have power that of a court and have capacity to order interim measures and can also appoint private receiver but not a court receiver. Along with that, he mentioned Shakti International Private Limited versus Excel Metal case. Section 9 passed that arbitration proceedings shall commence within 90 days period. Aforesaid, he mentioned firm Ashok Traders versus Gormukh Das Saluja case, where issue was whether relief under Section 9 grants relief if arbitration clause in arbitration, that particular arbitration agreement is not sufficiently or properly stamped and pending before Supreme Court itself. He also defined how non-parties of arbitration agreement can implead if they are affected by relief. Section 11 states that the appointment of arbitrator. Section 11 is also familiar to us because this has been much discussed topic on the previous session. We are aware that parties have freedom to choose arbitrators. It will be in odd form like 1, 3, 5, etc. Section 27 is a section which discusses about the court's assistance in evidence, and Madhavendra Singh sir mentioned competence part 2. According to rules, it is up to the competent court to grant or reject request of taking evidence. Then, as per section 29A, depicts the time limit for arbitral award. This particular section was introduced to virtue of Arbitration and Conciliation Act 2015 amendment, and if award not passed in 18 months, provision stipulates unless competent court grant extension. He also mentioned section 31A and 34. Section 31A, it says that constitutional regimes, a tribunal has discretion around about the courts and all. Section 34, this particular stipulates grounds to challenge to award made under section 31. Challenges to award can made with limitation of 3 months from date of receipt. He did mention section 42 and 43, which court will have exclusive jurisdiction. Section 42 aims those era, like it aims at avoiding conflicts in jurisdiction by placing supervision to one court for all arbitral proceedings. Scope of intervention of courts also deals with the provision like 37 clause 1, 2, 3, where 37 clause 1 aims appeals from the orders like refusal or granting of reliefs or set aside of award, etc. Section 37 clause 2 says with appeal from order of tribunal, and along with that, section 37 clause 3 says no second appeal from an order in appeal under the section. Only appeal to Supreme Court. Section 39 is lien on arbitral award and deposits as to cost and all. Then section 43 deals of limitation. These were the sections which are defined on the previous sessions. Intervention of courts can be broadly classified into 3 categories. These categories, which is for facilitation, it comes under section 8, 11, 27, 39. Then interim or conservancy, where section 9 and 17 constitutes. When then supervisory like section 13, 14, 15, 29A, 31A. Okay, all these sessions. Then the final is adjudicatory, where section 34, 36, 37, 43 comes. So as we know, Sri Madhavendra Singh sir was as an expert of maritime law and arbitration. He quoted that people often get confused on the difference between maritime law and maritime arbitration. So maritime arbitration and maritime law has its own difference, and we must not confuse on it. It is an unique version. Mostly parties opt experienced industrial arbitrator who knows actual pulse of ship, sea, and the techniques inside the ship and all matters about that. Then we must, and as an arbitrator, we must understand IBA guidelines, UNCITRAL model, New York and Geneva conventions. Then, and at last, we must know our own Arbitration and Conciliation Act. So these were the things sir mentioned on the previous session. So this is it. Now I show my immense gratitude to Sri Madhavendra Singh sir, who almost covered every aspects of the particular sessions of the previous session's topic. And I thank Advocate Johnson Gomez sir and Safi sir for holding these arbitration program. And I welcome our speaker, and I wish everyone have a fruitful session ahead. Thank you so much.
Thank you, Amina. I hope this made us recall what we had learned in our previous sessions. Now, I'm indeed delighted and honored to have with us our most respected speaker of the day, Advocate Krusch Pathippallil Antony, Associate, Chartered Institute of Arbitration, United Kingdom, Certified Mediator, Indian Institute of Arbitration and Mediation. We are very much pleased to have you with us, sir. Welcome, sir. And also, I would like to welcome our strong pillar of engagement throughout our previous sessions, Advocate Johnson Gomez, sir, Director, Cochin Institute of Arbitration. Welcome, sir. It's my honor to welcome you both to today's session. Now, I would like to invite Advocate Krusch Pathippallil Antony, sir, to proceed with the session. Sir, please.
Thank you, Brahmi. And firstly, I am thankful to Advocate Johnson Gomez sir for inviting me to this program. And I understand that Johnson Gomez sir is taking a lot of initiative to spread the message of arbitration. Now, this I believe is an attempt to take it on to students largely to spread the message. So once again, I thank him. Now, the topic of the day is hybrid form of arbitration. I have some of the PPP presented to be presented before. So the PowerPoint I would like to present. Hope you can see my presentation. Hello.
Yes, sir.
Are you hearing? Are you hearing?
Yes, sir. You are audible.
Yeah, my presentation is visible.
Yes, sir.
Are you seeing?
Yes, sir.
You're seeing. Okay. So the topic is hybrid forms of arbitration. Firstly, I am trying to define what exactly the hybrid dispute resolution. So hybrid dispute resolution is a combination of various forms of problem solving application, and it is thereby truly an interdisciplinary approach. So the varied forms of alternative dispute resolution forms are being combined. So that is how it is being defined in hybrid dispute resolution. And basically it is using various aspects in a dispute management or a conflict management with the options of diverse methods of communication tools. So this is how the hybrid dispute resolution usually happens. So the hybrid dispute resolution is a right mix, it is told, of various dispute resolution methods within ADR and litigation. So within ADR we have a lot many of dispute resolution methods, including conciliation, mediation, and arbitration. These are the three major forms, and further with the negotiation, expert determination, and so on. So how these forms can be mixed together in various permutations and combinations, that is being the discussion of the day, or that is being the presentation of the day, especially how we mix it with arbitration. Going on to the next module, we have a rich menu of ADR. So the rich menu of ADR gives a clear process, a clear method which can combine the elements into various methods. And the most common of the HDR process is the mediation and arbitration, which uses the same individual, or at times, there are different professionals, either as a mediation part, the mediation experts will come, and when it comes to arbitration, the arbitration experts will come. So it all depends how the country and how the arbitral law of a particular nation permits, whether the same person can be a mediator and arbitrator combined, or he can change the role, or professional has to step into. All this we are trying to look into. So designing hybrid dispute resolution. A dispute resolution process, while designing is a very important aspect. So working together on the architecture of a mediated solution. So how to mediate and how to architect how to design a process of dispute resolution. This often is the first task which lawyers or in-house counsel faces in the dispute resolution method, wherein which uh, the process of dispute resolution is being defined. The ADR professional in possession of prudence, flexibility, or sensibility in order to timely select and facilitate the process of moving from one way of dispute resolution to the second one or the third one, as and when need arises, as and when change comes. So this exactly is the requirement of the designing the way in which hybrid dispute resolution we can design while we are drafting a contract. So it is being told that it is about permutations and combinations of different methods of dispute resolution. So the different methods of dispute resolution is being combined, and these combinations are being collectively called hybrid dispute resolution. And within the hybrid dispute resolution, now today we are focusing how the very many facts of very many methods of dispute resolutions are combined with a particular method of arbitration. The broader concept and the broader combinations and permutations which are mixed with arbitration, I am just taking you quickly through that process. At this process, the first one is we often call as MEDALOA. MEDALOA is nothing, it is mediation come arbitration. So in a mediation come arbitration, definitely the supporting clause in a particular agreement, or these the parties themselves go for or agree for a MEDALOA clause. The starting point of the dispute resolution will be uh, a mediation. And once the mediation is into difficulties or an impasse is reached, the same person, usually in many of the places or jurisdictions, he serves as an arbitrator. So this is how the simple way to define MEDALOA. Further, we go on to the second mode, which some experts call it as ARB-MED, or others call it as ARB-MED-ARB. So, in comparison to the previous MEDAB, which starts with a mediation and ends with an arbitration, the second method start with an arbitration, then go for a mediation. So, if mediation settlement efforts in between fails, again it goes back to arbitration. So that's why it is called ARB-MED-ARB. Here, usually the appointed arbitrator attempts to mediate or conciliate the case, and in failure, he returns to his role and takes up the role as an arbitrator. So these two, in very many jurisdictions, the very same person is acting as an arbitrator first, then as a mediator, and if again, if settlement or conciliation efforts are failed, he takes up the role of an arbitrator. So this is how the shortest way we can define ARB-MED-ARB. The next and the third one, usually it is being called as co-MED-ARB. Co-MED-ARB, as the very name signifies, it is a mixture wherein which a mediator and arbitrator together takes up the dispute resolution. So both will be present in the arbitration. So the so-called dispute resolution, but the process is slightly different. Here, though both are there, the mediator proceeds initially for an attempt to settle the matter without the arbitrator. He tries his individual efforts to settle. If he fails, if the mediator fails, definitely the arbitrator is called and arbitrator will arbitrate. If the mediator succeeds, definitely again the mediator is being called, but here not for dispute resolution, but for making a consent award. So this is how when both professionals come into picture, but each one tries his own effort individually and tries for a dispute resolution. But unlike the other two modes, here we have two separate professionals from two separate disciplines. The next one is MEDALOA. MEDALOA I'll explain in subsequent slides. Here I am trying to take you through a dispute resolution clause, how MEDALOA clause looks like. So these slides give you an idea as to a dispute resolution clause of one of the international dispute resolution institute, which is named as Prime Dispute Resolutions, where the MEDAB clause is being explained. So I'm just taking you through their, the clause. So the dispute resolution clause here says that in the event of a dispute arising out of or relating to this agreement or contract, the party shall first seek settlement of the dispute by mediation in accordance with the extent prime dispute mediation rules. So this is a mediation institution. So the mediation institutions definitely will have their own rules. So the dispute resolution clause, if somebody is accepting and as a part of their contractual dispute resolution process, they are to agree with the institutional dispute mediation rules. Then the clause further reads, unless otherwise agreed by the parties, the mediator or mediators will be appointed by prime dispute. The parties agreed to be bound by any settlement agreement reached. If the dispute is not settled by mediation within the period as the parties shall agree in writing, the dispute shall be referred to and finally resolved by arbitration under the rules of prime dispute, which rules are deemed to be incorporated by reference to this clause. So an institutional MEDAR clause we are looking into, wherein which the particular case is related to an international dispute resolution institution. They have separate rules for mediation, separate rules for arbitration, and they have separate panel for mediators and arbitrator. If we are opting for this kind of dispute resolution, we will have two professionals acting within a contract, within a dispute resolution under two different rules, one under mediation rules and one under arbitration rules. So this is how the law and rules take shape in a contractual dispute resolution clause, where of a hybrid or a mix of MEDAB clause comes into picture. Now subsequently we can see the further down the paragraph which says as to the location and the seat, where the seat of mediation, where the seat of arbitration. All this is very relevant for a contractual dispute resolution as to the process of mediation and arbitration. So those things has to be clearly spelled out, and the language to be used in mediation or arbitration, that also has to be properly recorded in your contractual clause. The number of mediators or the number of arbitrators, that also has to be recorded, and what laws is governing to the contractual dispute resolution, that also has to be recorded, and which panel we are using, the mediator or an arbitrator, so that to be clearly spelled out. Otherwise, the selection of arbitrator or a mediator can enter into another dispute within the dispute. So it also has to be form part of this MEDAB clause. So this is one of the suitable institutional MEDAB clause, which is more safer than the ad hoc method of MEDAB. Now I'm taking you to the next one, which is well known, Singapore International Arbitration Centers, Arbitration Center as well as Mediation Center. So this both institution, by institution itself, they are very separate. But when it comes to a dispute resolution, they are joining together and offering a solution. So this is called SIAC, CIMAC, MEDAB model clause. So the MEDAB model clause, which we are discussing, is about two separate institutions in a country called Singapore. One is under arbitration and one is under mediation. So there are separate institutions offering a dispute resolution within a clause in a hybrid format. If you go into reading into this kind of dispute resolution clause, we can see, I'm just reading, any dispute arising out of or in connection with this contract, including any question regarding its existence, validity or termination, shall be referred and finally resolved by arbitration administered by Singapore International Arbitration Center, SIAC, in accordance with the arbitration rules of the Singapore International Arbitration Center, SIAC rules, or the time being in force, which rules are deemed to be incorporated by the reference in this clause. The seat of the arbitration shall be wherever it is, Singapore or whichever place. The tribunal shall consist of how many arbitrators, so that has to be. The language of the arbitration shall be, what language we have to use. The parties further agree the following the commencement of arbitration they will attempt in good faith to resolve the dispute through mediation at the Singapore International Mediation Center in accordance with SIAC, CIMAC, ARB-MEDAR protocol for the first time being in force. Any settlement reached in the course of mediation shall be referred to arbitral tribunal appointed by SIAC for a settlement award on an agreed terms. So initially we looked into a MEDAR clause and understood what exactly the clause look like and what all things to be incorporated under an institutional rules, wherein which we saw that the very same institution, which is prime dispute resolution, we saw that they have separate rules on arbitration and mediation and separate panels on arbitration and mediation, and they have clearly explained in that clause, the model clause, they are following separate rules, separate professional, and it is very clear. Now, when it comes to the RMEDAR model clause of Singapore, we could see that this facility is being offered in Singapore by two institutions as such, and they are governed under separate rules and laws. But once the dispute comes, they can use their services as per the rules of these two separate institutions for a single dispute resolution. So this is how what the beauty of a hybrid dispute resolution clause, especially like RMEDA situations. One of the case laws which I would like to invite your attention, this is related to US Steel Mining Company versus Wilson Downhole Services, a case law from US in 2006. Here the parties had agreed to have the mediator serve as an arbitrator if the mediation failed and failed to, for a resolution. The very same mediator is being considered or is being empowered as new arbitrator of the dispute, and once the new arbitrator he takes up the role, the arbitrator has to select between the parties the competing proposals in a baseball arbitration. So here we could see in this dispute resolution, it's not just MEDAR, but MEDAR finally taking shape of MEDALOA. The MEDALOA is a process in which arbitration is called baseball arbitration, which gives the arbitrator a different role. Of course, I'll explain MEDALOA in subsequent slides better. So here, the parties have expressly authorized the mediator, then arbitrator, to rely on confidential mediation disclosures in reacting to his decision. So this is very important, especially the divide between mediation and arbitration. We have to understand in mediation, the confidentiality criteria and principles involved is very high, and the concerned mediator has to preserve that confidentiality. And while the same person acting as an arbitrator, he cannot use the confidential information at all. That is being prohibited. He cannot take that into his mind at all. So this is where certain countries prohibit the same professional acting in dual capacity, and they have separated the professionals for different roles. But we can see these kind of case laws which empower the same person to act as a first as a mediator and then as an arbitrator, wherein which there is an express consent is given. So in some of the jurisdictions, in similar situation, if there is no express consent provided, it will be very difficult once a settlement reached. The other party can contest the matter, stating that somebody has used the informations which are confidential in nature in mediation, is being influenced or is being affected or is being used by the arbitrator for deciding his disclosure. This case law gives the picture that such an expressed consent can save the parties or save the arbitration or a mediation in the end from getting into dispute, into litigation, further litigations. Of course, we can see that this is a kind of MEDALOA, the last offer or the baseball arbitration model. So the risk is very less on the parties because the arbitrator cannot take any other decision other than the either of the two decisions only as per the MEDALOA. So that is how the MEDALOA works out, and it seems to be one of the good method of resolving dispute resolution. Next slides, I'll explain how this works, MEDALOA works. The MEDALOA, the mediation and last offer arbitration. So this is a mediation and last offer arbitration, which international terminology, different experts use the terminology different. Some of the experts say that it is MEDALOA. Some of the experts say that it is baseball arbitration. So this is how it is, it is being often used, this kind of dispute resolution method within the arena of sports professionals and other professional employment contractual dispute resolution. This is being used. That is how the name of baseball arbitration people are calling it. So in general, we can say at the conclusion of an unsuccessful mediation, the mediator considers each party's last offer, and so usually the mediator takes the role once he fails as an arbitrator, and here the arbitrator, in fact, in a mediation and last offer arbitration, it is actually arbitrator. The mediator takes the role of an arbitrator, and he considers the party's last offer. So each party is given an opportunity to make last offer, like the last quote, what best they can do, or what's the last price, or what's the last contractual value you can offer to the each other, to the other party, or in a football or a cricket or in any other sports, what exactly the last price which a club can offer, or somebody can offer to join as a club as a last price. So this is how the last offer from either of the side then makes the decision as to which offer is the most reasonable. So the arbitrator job is very limited now. He cannot split the offer, or he cannot come with a third kind of settlement. Either he has to go along with the claimant offer, or he has to go along with the respondent offer. So he cannot split it, split the difference. So that is where the limitations on the this mediation and last offer arbitration. So there is a limitation. The limitation is the last offer. You cannot modify it subsequently. That's the end of it. But the beauty of this subject is now, once parties know that the last offer is going to hit them towards the end of a mediation process, both parties will try their level best to have an amicable solution. So before reaching into the last offer arbitration, the mediation, there is a high probability that it will come to a success and it will be a fruitful mediation. The other important mode of hybrid dispute resolution is co-med-arb. Here, the co-med-arb, the very word indicates that a procedure where the tasks are performed by different persons. So in another format like MEDALOA or the RMED-R, most of the cases we could see that the same person is being assigned with the task of both, either as a mediator or subsequently as an arbitrator, or as an arbitrator, then mediator, and again goes back to an arbitrator. So the same person is taking different roles. But in co-med-arb, it is not possible. It is very clear that the task is assigned to different professionals. So in this procedure, the two neutrals, an arbitrator and mediator, it is very clear that they have to jointly preside over an information exchange between parties. So the case is being heard by two neutrals together. So this is how they hear the process. But subsequently, the mediation efforts conducted by the mediator will be in the absence of an arbitrator. So though the process starts with the two neutrals, either as an arbitrator and as a mediator, both will have separate way of professional conduct and mode, but they preside over together, and they exchange the initial informations, initial hearing, procedural hearing they will hear. But once the mediation starts, the mediator will take over in the absence of the arbitrator, and if a complete settlement cannot be reached, a binding decision of any remaining issues will be taken over by the arbitrator. So once the mediator fails his efforts to settle the matter will be handed over to the professional, the other professional, who is an arbitrator. He will take over. So there is a clear understanding, clear division, what exactly one's job. Though they start together, ultimately they end in separate in their professional capacity. So this seems to be a better option to avoid the complications and other confidentiality issues as to disclosures, professional capacity as to their terms and conditions with the institution. So all this is being protected in this particular mode. In the prototype for such a combination is mediation and arbitration, MEDAR. See, where the same person first acts as a mediator, and in the event the mediation fails subsequently as an arbitral, he takes as renders an arbitral award. So MEDAR has been praised for its efficiency gains, condemned in resulting for confusion of roles that jeopardizes both effectiveness of mediation and integrity of decision making in arbitration. So this is where, considering the traditional mode of hybrid dispute resolution of combining the MEDAR, mediation and arbitration, or ARB-MEDAR, the same person acting in dual capacity at different times, there is a confusion of roles, and there is an integrity issue also can be alleged, especially into the arbitration process. So this is being considered as a serious issue in international arena of dispute resolution, and they have come up with a decent solution, which is called co-med-R, where the process is very much clear, and the combination is having a demarcated boundary they have between the arbitrator and mediator, and when they have to come in, when they have to take up, and when they are delivering their justice, reaching to a conclusion. All this is being very clear when we have a dispute resolution clauses as co-med-R. Going back to the world as such, we could see another form of mode of litigation which is coming, hybrid form is coming, which is being called as arbitration. This is more happening towards the gradual blurring of different lines between arbitration and litigation. So the arbitration and litigation is now somewhat, the arbitration is slowly taking some of the traditional ways of litigation, especially the kind of extensive discovery evidences and other procedural complex things which is happening in the traditional litigation. Now arbitration is also opting for the same, and this process is happening more in common law countries, where they opt for extensive discovery methods and evidential procedures. And this is where experts now trying to say now the arbitration is taking the color of litigation, or some of the experts feel that, okay, the beauty and the benefits or the plus of litigation also come and joins with the arbitration, and they feel that to be combined in arbitration, some of the process of litigation. So this is another hybrid format which is coming in, and people are calling it as arbitration. Just for introducing that particular terminology and understanding, I'm sharing the same with you. The other important aspect of hybrid, which is happening and evolving, is a mixture of counseling, mediation, and arbitration. This is more true considering the aspect of debt dispute resolution. So debt is considered to be burdensome for many people, especially we know that debt-ridden farmers, farm suicide, all these issues are there throughout the India and some of the other foreign countries too. So there are some process evolving where a dispute is being initially when one of the side or party is very weak. The creditor or a debtor dispute, we understand that creditor is on an upper hand and debtor is, psychologically, mainly, he may not be fit enough for a dispute resolution at all. So instead of taking immediately into a dispute resolution process, the best thing is a combined way of counseling to be given as which the party is being empowered to mediation, and in mediation, if successful, good. If not, the parties are sufficiently empowered to take it up in an arbitration and to arbitrate the matter. So these kind of examples and experiments are happening. So one of its first experiment happened in the University of Notsa, where the extension program, they administered a program called Mandatory Formal Intermediation Program. So this happened somewhere back in 1986, where they had so many cases of farmer with disputes, and they have huge debt burden, and courts got piled up with so many of the litigations. So the Minnesota University administration team took up this particular program, and they started counseling and mediation centers. They started, and court also permitted for the first time. This is what happened in the United States, to have a counseling of mediation, and once above you arbitrate and resolve. So they had almost 24,000 cases in the background of this particular debt-ridden cases in 1986 they have resolved, and that is one of the big or best case studies as to this hybrid format, how they effectively used. So this hybrid format, you can say that in a dispute resolution format, they use the counseling initially, then maybe some of the counseling succeeded or failed subsequently, and a mediation, mandatory process of mediation, and if failed to arbitration, or if not arbitration, they must have gone for litigation. So this is how they have structured the entire format of dispute resolution in a step-by-step process, which is in hybrid format, which also I am discussing with the students and others for an understanding how the combination works well, rather than going on a straight jacket formula. It is, we know that one jacket or one suit may not fit all. So we have to invent this process of hybrid, the combinations and permutations, and try to get best out of it for a dispute resolution. That's been the goal of a dispute resolution process, professional, especially an arbitration or a ADR professional. So in this context of hybrid dispute resolution, I'm just sharing a slide in which how the dispute resolution process happening in a step-by-step format. So this step-by-step format, you can see that the dispute resolution in different stages and steps. This is based on escalating model. So the escalating, initially there is the hostility level. Based on the hostility level between the party, then the cost and time factor involved. So initially, people should not, or any professionals or parties should not try for the extreme way of litigations initially. They should try for different styles and mode they have to opt. So the escalation metrics, we can say, or dispute resolution stage by steps metrics, we can say. So initially, they will have a kind of method of prevention and cooperation stage, and that's the first stage. Then they go for a dispute de-escalation stage, where control and real-time resolution stage. They take various methods. So that's the stage where the neutrals step into dispute resolution process, and if they can act in subsequent stages as mediators or conciliators, or they can even have the other forms of dispute resolution like mini trial. And if nothing works out, then the next format it is being suggested as an arbitration. And finally, the arbitration so doesn't work, or if again dispute persists, it's litigation. That's the only way to end, to the forceful enforcement of the resolution. That's the only end towards the entire process. So this is that's why it is being called escalating hostility, cost, and time, a kind of metrics which a dispute resolution expert to keep in mind. And the hybrid format, in fact, allows somebody to use in a single form or at one time to use the steps higher and steps lower, combined and standing in middle, and often you can cut across the steps and try your level best which suits for you and drive to a dispute resolution. So that's where the beauty of hybrid comes. Otherwise, if you take more steps, you cannot come down, or if you are very, down in the stair, you cannot take, go up all of a sudden. Whereas if you offer a kind of hybrid, you have a facility to go up and down in between as per the stage and situations or circumstances of the case. So that's the beauty of hybrid dispute resolution. A broader question or a larger question, can we combine mediation and arbitration? This is a very large question which is being discussed throughout the world. Some of the professionals are having different views. If at all it is combined, what best combination we can do, what plus we can get, or what negative, what are the minuses. So we are looking briefly into these kind of issues. In arbitration, the arbitrator is charged with managing the proceeding efficiently, providing a fair opportunity to each side to present its case, and analyzing the facts and the law based on the evidence to arrive at the ultimate award. So the arbitration, the role of arbitrator is very clear. He has to analyze the facts and he has to base it and judge according to the evidence available. Ultimately, he has to give an award. So this is how the arbitrator's job is very clear. Now the mediator's job, let us see. The mediator is charged with working with the parties to craft a process most likely to lead to a resolution, uncover the parties' interest, understand their relationship and their motives, explore the strengths and weakness of the respective position. So we could clearly understand that the arbitrator is no much more interested, or he should not be much careful about a resolution or a settled resolution. There is no compulsion for an arbitrator or an arbitrator beyond which he should not go for act as a facilitator for a dispute resolution. Whereas the primary job of mediator is a facilitator job. To lead to resolution is what is the ultimate interest of a mediator. So there's a divergent outlook from the professional perspective of an arbitrator and mediator. And further, mediator assists in developing workable solutions and help the parties to overcome psychological barriers to settlement. So the main job of a mediator is to psychologically empower the parties and to overcome barriers or difficulties in communication, and empower them to reach towards and work towards a resolution and a settlement probably. So the working nature of both arbitrator and mediator are completely different, and combining these two, it will be a difficult scenario for most of the professionals. Of course, there are professionals who can combine, but the training, efficiency, understanding, analyzing capacity, the legal background, the psychological understanding, and exploration and empowering the parties as from a psychological perspective. All this may not be present in every professional, and combining this procedure to get such a professional will be very difficult. So that's the most important difficulty which people find to get an expert in combining the both and acting professionally in both camps. It will be very difficult. And lastly, the mediator's role requires use of many of the skills of psychologists. So mediator, more than lawyer or more than legal understanding or more than professional understanding, or the most important quality of a mediator to demonstrate his skills as a good mediator, psychology and psychological inputs and skills of the psychological input are more important to a mediator, and that's the most important skill where a mediator should or the mediator possesses. Whereas for an arbitrator, this is quite irrelevant, and arbitrator's role and his most important skill set is the requirement to analyze and understand the facts and the law as a skill of a judge to judge what exactly is right and wrong from the perspective of the facts submitted and evidences presented before him. So the skill set is extremely divergent, and that's the most important challenge which is being faced by combining these two and the task assigned to a single professional. So this is where the most important difficulty comes. And understanding this difficulty, that this is where exactly we could see initially some of the dispute resolution clause. Initially, a MEDA clause by private dispute resolution, where in which they have the same institution, but they have separate rules for mediation, separate rules for arbitration. They have separate professionals for mediators panel and separate professionals for arbitrators panel. And they select from those panels and use the professional ability of those mediators and arbitrators. Though they have a combined process as a dispute resolution, they use separate rules, they use separate professionals. So that seems to be the best. Same was the situation we could see the Singapore International Arbitration Center and Mediation Center. There we could see in the dispute resolution two separate institutions coming together and offering the service. So the institution itself is separate, not only rules or not only the professional. So this is how the combination should be ideally. This is how it should be. That's the professional opinion of me too, and that's how the world is emerging rather than assigning this divergent task to a single individual. Let us see how the MEDA work in India. So the Indian Arbitration and Conciliation Act, we don't have a mediation act as such. We have something of a conciliation mixed with Arbitration and Conciliation Act, and both are separate proceedings. Of course, we can see Section 30, Clause 1, and again Section 32, where you can see some of our writings as to the combination. Firstly, we can see the clause 30 as to subclause 1. It is clearly written that the arbitration agreement or the arbitration as a method, as a dispute resolution, the arbitral tribunal may use mediation, conciliation, or other procedures at any time during the arbitral proceedings to encourage settlement. So the primary duty of settlement and encouraging settlement is being utilized by the parliament or the legislatures at that time. And 1986 until now, there is no change in comparison. Our world has moved to hybrid dispute resolution, and nobody has touched this particular portion. But the wording which I have highlighted in red color, the arbitral tribunal may use mediation, conciliation, or other procedures. This gives enough scope, enough room for drafting an hybrid dispute resolution clause in India. It is sustainable, it is legally valid, and it is permissible. So how to happen it is, how to do it is. This clause won't tell us much, but the portion which I have highlighted in red, which clearly tells that the arbitral tribunal may use mediation, conciliation, other procedures means definitely they have to refer somebody outside from the tribunal to other mediation or reconciliation institutions, or as to ad hoc panel, or as a sole mediator or reconciliator, and take back the bundle once it's failed or once it's settled, leave the arbitration. So this is how it is being explained, or the parties can come back to settlement and give back to the arbitrator for a settlement award. So that's how the subclause 2 says. If during the arbitral proceeding the parties settle the dispute, the arbitral tribunal shall terminate the proceedings, and if requested by the parties and not obstructed by the arbitral tribunal, the record of the settlement in the form of an arbitral award on agreed terms. So it makes very clear in these proceedings, if the parties want to go for a settlement and uses the mediation or a conciliation and they succeed, then arbitrator is very free to terminate the proceedings. That's very easy. But if parties are requesting, instead of terminating the proceeding, they want to go for a settlement award under arbitration, arbitrator should not object to it, and he should record the settlement in the form of an arbitral award. So the clause section 30 and 30 clause 1 and 2, it's very clear we have in India too, a format of dispute resolution which can be combined effectively as an hybrid format and find resolutions within the available portions of section 30. The combining mediation and arbitration in, let me see, go back. Okay. Combining mediation and arbitration in a hybrid process with the same neutral can be an effective mechanism for reducing cost, increasing efficiency, possibility of achieving a result that optimizes the position of all parties and arrives at the best resolution of a dispute. If the parties are consent knowingly to the same level mediation and arbitration, party autonomy should be respected and resolution derived from the program. So this is a kind of understanding which I am presenting to you, the benefits of combining the process and assigning the task of mediation and arbitration to the very same individual. The beauty is that see, the parties need not go and submit the facts again and again, submit the evidences again into another forum. So two party, two professionals means the cost will be escalated, the time duration will be high. So why we should go for that? That is another important aspect which some of the nations and some of the jurisdictions are encouraging the mediation and arbitration to be conducted by same individual. This is being the Chinese law I have seen. They encourage this kind of format to reduce costs, and they say that once the parties, both, it's not a party, when both parties are very confident that my mediator can be a very good arbitrator, and my mediator, when becomes an arbitrator, he will not, use the confidential information or any other information which are not legally binding to be taken as binding or being considered take as a within the mind and apply that in the arbitration. So those are the fears which often comes. But when the parties are very clear, confidentiality conditions are very clear, and this will, once the parties are very close to the mediator, then why should we have another arbiter? There's a point in that. And this is party autonomy, certainly. See, when parties are very clear, there is no point in prohibiting or there is no point in having a law that permitting that you should take out another professional. It is party autonomy is one of the paramount and important step in the international ADR process, and we should respect that and we should honor that, and the resolution derived in this process to be honored. So that's how one of the conclusions which I am deriving. And finally, before thanking you, I would say, or I would invite your attention to an emerging format within the dispute resolution that is an emerging in-person and virtual, which is an hybrid mode. We all know that in international arbitration or arbitration, we had a process of dispute resolution either in one format, either you have to adopt for an in-person mode or you have to go for a virtual mode. So the pandemic of situation, the COVID-19, which posed the world a big question: should we, immediately go for a virtual by though the agreement is in person? Now the world across is coming, virtual is being promoted, and now the combinations are being recognized. Though the expert's vision was you cannot have a mixture. Either your proceedings should be in person or your proceeding has been virtual. So this is being observed as one of the important elements, and this is being considered as a professional view. But in the international arbitration observations and order in Australia, which clearly mentioned that you can have a hybrid mode. One of the parties or some of the parties can select in person, whereas the other parties can opt for virtual. There is nothing wrong. We can combine. So this also, I believe, is another format of hybrid mode in the arbitration procedural aspects, wherein with a mixture of in-person and virtual hearing is emerging. And I am calling it as an hybrid mode in the process of arbitration within, and this is being evolving. So this is where I am concluding the presentation as to the hybrid dispute resolution. Hope I have conveyed the topic to a reasonable level within the time available, and rest of the time with the consent of moderator and with the consent of Advocate Johnson, using for any kind of questions and probable answers or any other interactions. Thank you.
Thank you, Mr. Krusch, Antony. I have a few things to point out, actually, with respect to these concepts that were discussed. Actually, I have a question to you. Can you briefly explain how different is the fact-finding process of arbitration different from the process that is being employed in mediation? What are the important parameters or the factors that is deciding on the which are being considered in the process of mediation, and how different are these two processes of arbitration and mediation? Can you briefly explain the steps that we normally follow? You being an expert in the field of mediation, I think that you are the right person to brief brief idea, because we have never gone into the topic of mediation very seriously.
Thank you, Johnson Thomas, sir. I'll take you briefly, because this is again we are touching upon the process of mediation and process of arbitration. What we discuss now is the process of arbitration or the process of mediation. That is not being mixed at all in hybrid form. This is one of the important things I would like to say. The process remains same. The combination, though the combination works out, for example, MEDA. In MEDA, while we are doing mediation, the parties and the mediator has to agree for a process. If it is a ad hoc mediation, parties has to agree for a process. So the initial preliminary hearing of a mediation, the parties and the mediator will agree for a process. What exactly the process to be adopted? Whether the process is by direct hearing, or any document submission is involved in the process, or any third parties are to be heard or not, or any document only mediation, or if at all it is arbitration. So all this process to be, or any to be analyzed or understood, all the process to a mediation, the parties should agree with the mediator. If it is ad hoc arbitration, the parties and the mediator will decide on it. If not, they are bound by the mediation institutional rules. If the mediator finds it difficult to have an amicable understanding as to the process to be followed, the mediator can suggest to the party, I am selecting the mediation rules of XYZ institution, and I will be conducting the mediation as per the mediation rules available as per the institution which I am representing. For example, if I am a mediator and I take up a case, I am from Indian Institute of Arbitration and Mediation. If I fail to reach a consensus with the parties as to the mediation rules, I can opt for institutional rules. I will record it and I will proceed with my mediation. So this is how the mediation process goes on. It will have its own rules and process, which is agreed by the parties, or as per the institutional rules, we will take it forward the mediation. Now, when we come to the arbitration, similarly in arbitration too, we have a proceeding, arbitral proceeding rules. Either parties can decide in consensus with the arbitrator, and they can have a process as proceeding if it is ad hoc arbitration. Or in the end, the section 19 of Arbitration Act provides this facility to decide on the proceeding procedural aspect. In the end, the parties are not consenting, the arbitrator can decide as the process involved. And it is very clear that when it comes to an institutional arbitration, the institutional rules will govern. So this is how being the rules and the process is being compartmentalized within the mediation and within the arbitration. The professional conduct, the terms and conditions, and their ethics and morality all will be there as a mediator separate and as an arbitrator separate. This is where during the presentation, I also expressed the difficulty while combining the mediation and arbitration to a single individual. He will have difficulty to separate the process when he acts as a mediator and to separate his process to act as an arbitrator. There is a natural possibility that mixture of this process may come. So this is one of the difficulty. That is why I have given a couple of examples of the institutional aspects wherein which hybrid dispute resolution clause clearly demarcates the rules of mediation and rules of arbitration, and they have gone one step further, which clearly say that mediator is different and arbitrator is different. So this kind of confusion or professional difficulties are being avoided. So this is what I am explaining. If any other points to be deliberated, I can.
So the confidentiality issue seems to be a very big problem with the mediator, because a lot of confidential informations will come to the mediator during the closed, what we call caucus sessions, or personal sessions with one of the parties. And at the time when he goes to mediation, and suppose he is the mediator also, sorry, he is the arbitrator also. I think that he is the arbitrator also. Then it's a big challenge. I think that to overcome that seems to be a very, very, very difficult thing. I do not know how the impartiality can be preserved as is required under the arbitration process may need, because he has a lot of information by the time when the mediation fails about the subject matter that he is handling. Another question that I want to ask is, we have a Conciliation Act. In fact, Part 3 of the Arbitration and Conciliation Act is relating to conciliation. How different is mediation and conciliation? How far it is different, the process in a mediation and a conciliation? What is the actual difference? Can you actually identify some difference when it comes to conciliation and mediation?
Yeah, this is a very interesting question and very difficult to answer. I agree with you. See, there is in general internationally what is accepted as the difference between conciliation and mediation is conciliation is more of a statutory in nature, wherein which the conciliator is being appointed by a statutory authority. We can see the conciliation process in labor laws in India, where the labor dispute resolution comes, it goes to a conciliator. Similarly, corresponding provision we could see in some of the enactments, wherein which by the enactment the role comes as a statutory role comes into way. But that is one of the in general accepted world over definition of difference between conciliation and mediation. And the important thing, the question which is being posed, what exactly then our Conciliation Act tells? See, our Conciliation Act, to my greater understanding and knowledge, my point of view is that it is another terminology which we use for mediation, is my point. It is no much different from the mediation, which is we are trying to talk of mediation. The very same thing is being talked, and very same thing is being written as a conciliator. The difference which I am trying to see is when it comes to mediation international, we can see that globally mediation to be undertaken by a trained person. because globally we could see mediation involves a lot of psychological and a lot of other managemental and a lot of other procedural training involves in mediation. So the world over, when we say about mediation, it is more of a trained professional, and most of the world international practice see the mediator to be a trained professional. So that's how 40 hours international training has come and recognized world over. So, and accreditation programs, continuous programs, training programs. So it's a trained program, it's a professional program. So mediation is very trained and mediation is a very professional different. Whereas conciliation, very clear, there is no matter. The parties can bring any third party. There is no qualification prescribed. There is no training prescribed. Conciliator should be any third party who should facilitate settlement. It is more, the word is very clear, settlement agreement. So the conciliator in a conciliation is helping the parties to reach to a settlement. He is just facilitating it, he is witnessing it, he is countersigning it, and he can make the process as complied under the part B of the conciliation to be an award. You print it in a stamp paper, you countersign it, you countersign with witnesses, and make it as a conciliation award, which is binding in law. So it is more of a settlement facilitator, settlement agreement. Whereas mediator's job is a more of a professional job. Mediator invent opportunities. Mediator takes the parties to greater levels of psychological understanding, or even in a commerce to a deal making process. A trained professional. So mediation process is very professional process. It's a training process, and mediations we have world over accreditation process, training programs. They have terms and conditions assigned on their tasks. They cannot violate the code of ethics. There is a presence of code of ethics is available to mediator. If mediator violates the code of ethics, the mediation license will go. Forever he is have license. Whereas conciliator has no code of ethics, there is no accreditation, there is no license, anybody can do it. So I hope this is the best way to distinguish both and to say that both are different, but ultimately trying for the same thing.
I think that Paul has a question. Paul,
Yes.
Paul, do you have a question?
Participants, now we have got an interactive session for 10 minutes. So if you have any doubt, you can unmute your mics and ask the question.
Actually, there was a problem with my child playing. I mean, suddenly coming and tapping on my mobile, and I don't know what happened. So sorry about that trouble. And partly I couldn't hear. I could hear only part of what you had, what you discussed. So about again, Johnson sir. Actually, you happened to say about the arbitrator telling. I mean, getting the arbitrator into some kind of confidentiality agreement. I think that would be a better idea, because if we can get the center where the arbitration is done, if you can have the arbitrator to get into the confidentiality agreement, that would actually cover up the entire, the problem of keeping the trade secrets within the conciliation. I don't know how far it would be helpful.
Yeah, it is. Because please.
Come on.
Yeah, as I was trying to explain, world over these issues are being deliberated, and institutions already have come up with the rules. Separate rules as to mediation, separate rules as to arbitration, and most of the jurisdictions allow separate professionals to deal with the subject. Of course, as I told, jurisdictions like China, they promote the same person as an arbitrator and a mediator. They feel that that's the best thing to work upon. In such cases, definitely there is a confidentiality factor involved, as Johnson Gomez sir has told. So the confidentiality issues when you act as a conciliator or a mediator, it has to be protected, and the parties or the institutional rules can govern it and can contain it to appropriate methods. But still, though you write and do, see, when you are acting as an arbitrator, you have the same inside your mind, and there can be an element of bias which nobody can control it, because you have seen something which is, or you heard something which is against one party, or you feel that that is something wrong. When you pick up something like that in your mind, from that perspective, I also go with Johnson Gomez's understanding that the confidentiality can be an issue, and this is where I go with jurisdictions like Singapore, where in which they don't permit this to be done by the same individual. They are very clear on this subject. It has to be a separated individual. Though you can have an hybrid one, your rules has to be separate, or your proceeding to be conducted by the concerned professionals. It's very clear. So I also support that view personally.
I have actually, this is my understanding that I want to share with you, and I just want to verify whether I am correct. In the conciliation process, a conciliator has the option of giving suggestions for a settlement. In the mediation, the mediator would only encourage the parties to come to a settlement. Am I correct? Is it?
Yes, Mr. Johnson Gomez, as I told, this is very, very correct, because the conciliation, as I told, he is a facilitator for settlement. So he should, he got a task before him. He should reach towards a push towards settlement. There's an element of pushing towards settlement is present in conciliation. This is where the statutory, the governmental or some other institutional interest coming, and even in private also, when you are a settlement facilitator in between two parties as a conciliator, you always want to see that parties reach a settlement. Whereas in mediation professionals, it is none of the mediators' concern. Mediators at the most should facilitate the negotiation, should create a ground, but mediator should not push towards settlement. Mediator has nothing to do with pushing or giving suggestions or giving innovative ideas. No, you don't have much of a role in that until and unless sought by the parties. Whereas in conciliation, conciliator pushes the parties for settlement. He comes up with the third proposal. Also, he may come. He is empowered to do that because he is basically a negotiator and trying to settle the matter. And he wants to settle the matter. He wants to see that. That is his job. Whereas mediation, that is not the job. They are trained. They are just either empower the party or facilitate the party, or there is a clear neutrality is being maintained. They just see through the processes being adhered, and they just have a comfort level kept in the parties, and they keep the confidence, they keep the secrets of the party, and they will divert the information wherever required with the consent of the party, only towards reaching and guiding, more of a guiding role, not as a pushing role. Whereas in conciliation, there is a clear push to settlement is happening. So this is exactly what you told is correct, and that's how it is happening. That's the act also says that conciliators should try for settlement or put suggestions is being mentioned.
I have one more point actually, which you can better clarify, because I am not having that expertise in the field of mediation. So a dispute will consist of a bundle of emotions of the parties and some facts where they have some rights. And what is the role of this dealing with emotions of parties in a particular dispute resolution process?
Yeah, I think you are coming to a clear distinctive point between mediation, between conciliation and arbitration. Rightly told, mediators are dealing with psychological inputs. They should have psychological skills, and they often deal with the mind of the people, whereas a conciliator or an arbitrator doesn't deal with the mind of the people. So a mediator reads mind of the people. A mediator should take into account the very emotions of the parties. They should control. They should help the parties to recover from emotions. Actually, it's a kind of healing method. It's partly a kind of counseling, empathy, an element of empathy. The right word is element of empathy. Empathy is the most important, or one of the important element in mediation. Whereas for a conciliator, there need not be an empathy at all, because he is not doing that. He is not in emotions. He is into that, not into that. Where arbitrator, definitely, he has no connection with this. There is no empathy or so-called sympathy, nothing. You deal with the facts, you deal with the evidence, nothing more. To an extent, the conciliation stands in between, to my understanding, between mediation and arbitration. He is more of a neutral, wherein which he don't deal. He has no connection with the deal with empathy or sympathy. He's not into that. But he got a larger interest in settling the matter. Whereas the mediator don't have the larger interest in settling, but the mediator see through that the empathy part is being taken into consideration, the emotional part is being taken into consideration, and to stabilize the mood of the parties, encourage them for a sit together and discuss the matter, and to facilitate negotiations in a better environment. So he is more of a facilitating negotiator. Whereas the conciliator takes a part in negotiation, as you rightly told, with suggestions or with his own innovations he may come up. He is empowered to that. Whereas a mediator, he is not having that job. It is not his profile to come with a suggestion or any kind of innovative ideas. And he deals mostly with the emotional part. There is a definite role for a mediator to understand the emotional part, and you should deal with that. That a successful mediator is a person who successfully handles the emotions of the parties. It is whereas that is no connected to the other parties. So this is where I am trying to take out the point from what is being suggested by Johnson Gomez sir. Emotional part and empathy part is a key element in mediation, whereas it is not in other formats.
If any other participants have any other questions, you may post your questions. Otherwise, we will come to the close of the event. My charge is also getting less, so that any moment it can go out. So, is there any other questions? Otherwise, we will go for the concluding.
Hope no other question, and if at all anything, people can contact me, message me, email me, and I am thankful for this opportunity. Thank you, Johnson Gomez sir and the team. Thank you.
I hope there are no more questions to ask, so the interactive session is over. Thank you both of you speakers for your delightful words and valuable ideas. And also a very special thanks to our most respected speaker of the day, Advocate Krusch Pathippallil Antony sir, for sparing your time and enlightening us. And also, I would like to thank Advocate Johnson Gomez sir for being with us throughout all the previous sessions as a strong pillar of encouragement and support. And now, I would like to invite Mr. Harikrishnan to deliver the word of thanks.
Yes, good evening to you all. Am I audible?
If you are.
Okay. Okay, good evening to all present here. Me, myself, Harikrishnan. I am here in front of you to deliver a vote of thanks. So, first of all, I thank our special guest on behalf of LJRF institution, Advocate Krusch Pathippallil Antony sir, who have came here accepting our invitation, spending some part of his valuable time with us, sharing the valuable thoughts on the ideas of topic hybrid form of arbitration. It was really a wonderful section, sir. We were able to acquire more knowledge on this topic after attending this session. So thank you, sir. Thank you so much. Next, I would like to go on to thank Advocate Johnson Gomez, sir, Director, Cochin Institute of International Arbitration, who has been with us since from the starting of this venture. Thank you, sir. Thank you for the kind support and dedicated cooperation that's been shown towards us. Next, I am thanking the Secretary of this LGRF institution, Ajay Kamath sir, and the President Tejas sir for arranging such beneficial events for us. Thank you, sir. Thank you both. Next, I am thanking Safi Mohan sir, Assistant Professor of Government Law College, Trivandrum, who is acting as the mastermind behind all these events conducted by LGRF. Thank you, sir. Thank you for the kind support that's been shown towards us by you. Next, I would like to thank the coordinators, Neelima ma'am and Advocate Sunitha ma'am, for the work that I have been doing till now. Thank you both for the dedicated commitment shown towards us. And last but not the least, I convey my sincere gratitude and thanks to the technical committee members and the technical committee LGRF and to all the respected participants who have been here till now. By saying this, I conclude my talk. Thank you all.
Thank you, Hari Krishnan, for your kind words. We would like to thank you all for your gracious presence and participation in today's session. And now we declare the session is officially over. Once again, thanking you all. Stay safe and stay healthy.